What if an AI could actually feel the music you love? I don't just mean sorting it by genre or artist, but by its real emotional vibe. Well, that's the whole idea behind a pretty groundbreaking invention that ended up sparking a legal battle, a battle that went all the way to the UK's Supreme Court and completely rewrote the rules for patenting AI and software in the UK.
So how in the world did a music recommendation AI end up in the highest court in the land? Let's trace this whole thing from the beginning. We're going to follow all the twists and turns of this legal saga, from this really clever new AI through some dramatic court battles, all the way to a landmark decision that could seriously reshape the future of British technology.
Okay, so first things first. Let's really get to grips with the piece of technology at the heart of this entire legal drama. What exactly did this company, Emotional Perception AI, actually create?
What they built was a system that recommends music in a totally new way. So instead of relying on human-made tags like, rock or happy, or just looking at what other people listen to, this AI learns to understand the emotional essence of a song. It actually analyzes the physical properties of the music itself, things like the rhythm, the tonality, the timbre, and it figures out which songs are semantically similar, which is just a fancy way of saying they feel alike to us as humans.
Now, the really cool part here is the core technology. A normal computer program, right, is given a really strict set of instructions written by a human. But an artificial neural network, an ANN, that's different. You don't program it, you train it. You basically show it pairs of songs and you tell it, hey, these two feel similar, and these two feel different, over and over again. And it essentially learns to write its own rules, creating this complex model of musical similarity that a person would probably have a hard time even describing.
And this very distinction between being programmed and learning, that's exactly where everything got so complicated, because when the inventors tried to patent this brilliant system, they ran straight into a legal brick wall.
And yeah, this was not a simple rejection. As you can see, this case just bounced up and down the UK's entire court system for years. It was a total legal roller coaster, with each court offering a completely different answer to this really fundamental question: what is a computer program in the age of AI? So the first no came from the UK's Intellectual Property Office, or the IPO. Their reasoning was all based on the UK's Patents Act of 1977, which says you can't patent a program for a computer as such. Basically, the IPO argued that at the end of the day, this emotionally perceptive AI was just a really, really clever piece of software, and because of that, it was excluded from getting a patent. Simple as that.
But let's move on to the first appeal, because this is where the plot thickens. The company, Emotional Perception AI, they fought back. They took their case to the High Court, and that's where the story took a really fascinating and pretty unexpected turn.
In November of 2023, the High Court actually sided with the inventors. The judge looked at how this AI worked, how it learned and adapted on its own, and he started to wonder if it even qualified as a computer program in the old, rigid way that the 1977 law meant it. And this is the crucial observation from the judge, Sir Anthony Mann. He basically reasoned that because the neural network creates its own logic through training, instead of just following a script written by a programmer, it might be something else entirely. It wasn't a program in the traditional sense, it was a self-taught machine. It was a really different way of looking at it. But that victory? Yeah, it didn't last long. The UK's Patent Office was not convinced, and they appealed the decision. So the case then moved up to the Court of Appeal, where the legal pendulum swung dramatically back in the other direction.
The Court of Appeal took a much more, let's say, pragmatic view of the whole thing. They weren't really interested in the philosophical question of how the AI's logic was created. They were interested in what it ultimately was. And Lord Justice Burse laid it out pretty clearly. He argued that it doesn't matter if the AI is running on hardware or software. The network's final configuration, what they call its weights and biases, which are basically the parameters it learned that let it make decisions, is a set of instructions. It tells the computer how to process information. And a set of instructions for a computer is, well, it's a computer program. How it got there, he said, was totally irrelevant.
So you can see the fundamental disagreement right here. The High Court was all focused on the process, the act of learning, and they saw something new and different. The Court of Appeal, on the other hand, focused on the result, a set of instructions for a machine, and they saw a regular, if very complex, computer program.
This deep legal conflict basically meant the case had one last place to go, the final stop, the UK Supreme Court. And instead of just picking a side, the Supreme Court did something really bold. They decided to throw out the old rulebook entirely and create a new one.
In a truly landmark judgment, the Supreme Court basically said, look, the old UK-specific tests we've been using for software patents, they're confusing, they're out of date, and they're just not working for modern technology. It was time for a major change. So what they did was abandon this old, super complicated UK test. It was known as the Aerotel test, which frankly was often criticized for being a real mess. And instead, they decided to adopt the approach used by the European Patent Office. This is often called the convict approach, or more simply, the any hardware approach. And it's a massive shift in UK patent law. And this slide really lays out the new, much clearer path forward. The first question is incredibly simple. Does the invention use any physical hardware? A computer, a server, a smartphone? If the answer is yes, it's not excluded. Done. Then you get to the second and more important question. Does the new part of the invention provide a technical solution to a technical problem? See, it moves the whole debate away from is it a program to does it do something technically innovative?
So what does this all actually mean? The legal battle is over, the dust has settled. What's the real-world impact of this decision for inventors, for AI companies, and for the UK's reputation as a global tech hub?
Well, the takeaways here are huge. First, by aligning with Europe, the UK is sending a really clear message to global innovators. Our patent system is stable, it's predictable, and it's open for business. Second, it really lowers that initial barrier. It's now much harder for the Patent Office to just reject a software invention out of the gate. The focus is now squarely on its technical merit. And of course, for emotional perception AI, this is a massive victory. After a very long and expensive legal fight, their innovative tech can finally be judged on its merits, which paves the way for them to protect their creation.
So, this landmark case has provided some much-needed clarity for the technology of today. By shifting the focus away from these philosophical questions about what a program is to the more practical question of what an invention actually does, the UK has opened its doors wider to the AI revolution. But, as AI becomes even more advanced, this decision is probably not the final word, but really just the start of a whole new chapter for law and innovation.